Here we are for another update on the latest court filings on the Justin Baldoni versus Blake Lively case. Two battles have been raging. One was almost settled, the other goes on as well, but quite a few new filings showed up for us to consider. So let's get started. This is Legal Updates with Cassidy. An order, a summons, and a death on the set of Deadpool. How'd you keep that quiet, Ryan? First, I want to go back to the scheduling order for just a moment. This was a podcast I did on February the 8th where we went through the court order for how and when each phase of the trial should progress. Every trial has one of these, and most of the dates are determined by standard protocols. But as we saw in some of the recent documents, this case has exempted from some of those standards, like court-mandated mediation and discovery protocols, instead using this case-specific schedule. Now, I've heard some people wondering whether or not Blake might have some ace up her sleeve that she's not showing, and I wanted to point out how that is unlikely at this point. Why? The initial disclosures deadline has already passed. It passed on February 18th. Granted, that's the least complete disclosure, but it's supposed to include their preliminary list of witnesses and what those witnesses will testify to. Additions to that should come from things learned along the way, not from things they've been holding out on, because the whole rules of discovery are built around preventing a trial by ambush, and so holding on to any ace up her sleeve is exactly what it's there to protect against. So we can reasonably conclude that Justin's attorneys have a pretty rough outline of the witnesses and written discovery at this point. The phase they're in now is the phase of production of documents. So from those disclosures that were due on the 18th, and these are not court documents that we will be allowed to see, this is things that the attorneys share amongst each other that will eventually become trial exhibits. And from those, they request copies of anything that they want to see and will make a list of the people they want to depose. I also mention that as the reason that we have several of these documents. We've seen a back and forth battle on two things. One, the phone subpoenas, for obvious reasons, way too much of an invasion of privacy. But two, this fight for this protective order that we thought was finally resolved, but it turns out we got a couple of new filings while I was in the process of writing this episode. We previously spoke a little on these subpoenas to the phone companies, where I read out all of the people named and the dates that they wanted the info to cover, but we didn't get into the argument factor yet. This really is an excessive ask and a complete invasion of privacy in my opinion. And document 75 from Team Justin states this absolutely, and we talked about that. It was them voicing that this invades the privacy of third parties, as well as violates statutes like spousal privilege, attorney-client privilege, doctor-patient privilege, and so on. And my favorite line from that document was, "This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI." Next on the list, we had some sealed filings, and then document number 82 was a response from Blake's team about these subpoenas. And I just want to add here something I've been dying to say since I started reviewing this case. This is my first time to cover a case in New York. I normally cover South Carolina and Texas. I'm used to formal motions. Document 75, for example, would have been labeled a motion to quash and looked like a formal motion. This document would be response to a motion to quash, also a formal document. And I have to say, these Dear Judge letters still make me giggle. It's kind of hard to take them seriously because they don't look like official documents filed, especially in a federal case. But in document 82, Team Blake has apparently taken out their crystal ball to see when Team Justin prepared their motion to quash and what they intended to do with it. They cite the timestamps between the phone call and the filing, but I don't think 2 hours is insufficient for this level of an attorney group to write a simple 3-page motion. But okay, Team Blake, we're used to your wild accusations. But the next document, 83, is Team Justin's response. And we're going to go through this one a little bit. And they say that in their letter, the Lively parties misrepresent the scope of the subpoenas, contending that they seek only non-content records, such as call, text, and data logs, and not the content of any communication. They say that that is flatly false, because of a term that's used in the subpoenas, all documents. They throw in the federal rules here, and they say that documents is synonymous in meaning and equal in scope to the usage of the term documents or electronically stored information. This would include writings, drawings, graphs, charts, photographs, sound recordings, images, and other data or data compilations. So, they say if that were all that the Lively parties were seeking, were these call, text, and data logs, that's what the subpoenas would have specifically asked for, but that is not what they actually ask for. They go on that this request of the broadest possible scope and clearly encompasses content. And if all they want is logs, then their subpoenas should clearly state that. But as it's drafted, that's not what they're officially asking for. And they state that even if that's not what these companies would supply, that they're not ready for this to be seen upon production because by then it's too late. It's already been produced. They go on to say that the 2 cases that were cited by Team Blake in support of this action actually don't support it at all, with one being a criminal case, which has no bearing on the scope of a civil case like this one, and the second one being an employer trying to prove that their employee was engaged in non-work-related activities during business hours, and only something like a cell phone record could prove that. So they state that these 2 cases have nothing to do with the scope of this case. And they stress again at the end that these providers have already been contacted and they've already indicated that they intend to comply with the subpoenas. So, with the then impending holiday weekend and the fast approaching return date of the subpoenas, that's why they had no alternative but to move to quash the subpoenas. The next in line, document 84, is Blake's amended complaint, and that will be its own episode or series of episodes. Document 85 is a sealed order where the court tells both counsel to confer about this subpoena matter. Documents 86 and 87 were Leslie Sloan's motion to dismiss and then the memorandum in support of that motion, and we covered that in last update. And then we hear more about Jed Wallace's summons. Turns out it was filed with errors and has to be requested again. Now 89 is the other back and forth I told you we would consider. This one is not as contentious as the phone subpoenas at first. This one is about a joint proposal for a protective order that they want put in place to protect discovery. What does that mean? Referring back to the podcast about the scheduling order and the timeline of discovery, remember we're in phase 2 where they're requesting the production of documents. That means, for example, if there were any actual complaints that had been filed at any point to Wayfair or Sony, that would have been listed in the initial disclosures. And so now, of course, that would be something that would be requested for production. Now, I'm not saying these exist. I'm saying as an example. So, Team Justin could ask for copies of those. In the course of this phase, some of that discovery could contain private information, not just from plaintiffs and defendants, but also any third-party witnesses, such as someone who may or may not have filed a complaint. That complaint could contain sensitive information, embarrassing information, things that party would not want disclosed. So there has to be some protection in place for these things. This also involves film production. So there could be things like finance business, something that's competitive, anything that shouldn't be disclosed. So a protective order would need to be put in place to keep this discovery from being exposed to the public at large. They say individuals who have spoken out publicly in support of Blake have received violent, profane, sexist, and threatening communications. And that's disgusting. It's one thing to voice that you're not happy about a situation or to say what your opinion is or whose side you're on, but let's not do stuff like this. Let's not threaten or be gross. That doesn't accomplish anything anyway. They say that in fact one witness who is known publicly to support Blake, and it's someone who supposedly was written about in Justin's complaint, received a written threat indicating that their family would be sexually assaulted and killed unless the witness agreed to make a statement and give the truth. This is very extreme. I hope this isn't really happening, but if it is, that's messed up. But their concern is that information could violate privacy, expose them to threats, and create a climate of possible witness intimidation. And then, of course, they have to bring up the Steve Sarowitz quote that's been posted and reposted. This time at least they give more context, where he specified, not dead, but you're dead to me, so that kind of dead. But dead to a lot of people if they ever get me to that point. Where at first this was relayed as if it was a literal death threat. But what they're going for, we keep seeing AEO, it's attorney eyes only. So in addition to some of the discovery being named as confidential discovery material, they want this attorney's eyes only designation. And this document also contains 3 exhibits, which is an email stating that Wayfarer is okay with the proposal without the additions made by Team Blake, those additions being the attorney's eyes only. Exhibit B is the proposed protective order, and C is what's called the red line version. And these are great because when a document has had alterations, It's not easy to find them without flipping back and forth and comparing every line, but this will have any changes that have been made, usually underlined in red, or in red text. In this case, it's blue and red. So document 90 is the completed proposed protective order for the judge to rule on. And then we have another sealed order that's document 91. 92 is yet another summons request for Jed Wallace because the last one was done incorrectly. And 93, we're back to the phone subpoena fight. So after a conference, some of the matter was resolved. Team Blake agreed to withdraw the request for all documents. And also cell site location information, which was a ridiculous ask in the first place. But then it says that Team Blake refused to withdraw their request for call and text logs. Now, they claim that the reason that they subpoenaed these phone logs in the first place was to try to trace out when, for example, the crisis management team was called in to try to prove this smear campaign. But now it seems they want to know who everyone in this group of subpoenas called or texted, as in some cases we saw going back to December of 2022. That's ridiculous. And so Team Justin's concern is that if cellular providers produce call and text logs of all phone numbers with whom a Wayfair employee communicated, they will be able to use reverse phone lookup. I'm sure we all know what that is, but that's where if you have a phone number and you don't know who it belongs to, you can actually very easily put that phone number in and find who owns that phone number. So they're saying that would help identify doctors, lawyers, relatives, friends, any person with whom that person communicated, as I said, going back to 2022. And so they said they suggest that the subpoenas be limited to the specific phone numbers of parties and witnesses, because supposedly, as I said, that was the whole reason for the subpoena, to try to figure out when this campaign began. But Team Blake rejected that proposal. They want it all. But they say that they have not and cannot explain why they're entitled to all of this. They say that this is patently overbroad because it calls for information that has no conceivable relevance to any claim or defense in this matter. Further, that they have not shown any reason that they should be granted unrestricted access to plaintiffs' entire personal cell phone records during the time period specified in the subpoena, and that this information would include substantial data not pertinent to any aspect of this litigation, including information about personal phone calls, and that this raises significant privacy concerns. Imagine that. Anyone who's on any of these people's phone call list, even if it's a wrong number, it's going to be there. And they point out that even in a criminal matter, this is way beyond the bounds of relevance, and they call it a fishing expedition, which is what it was being called from the beginning. I wasn't ready to call it that, but now seeing this, I'm definitely calling it that. They want to see years and years worth of every phone call and every text for what might be part of a smear campaign. And then they cite a case that says that a Rule 45 subpoena must meet Rule 26b(1)'s overriding relevance requirement and may be quashed for failure to do so. And this rule was read out earlier. And then again, 94, summons for Jed Wallace. How many attempts is this now? Well, hopefully this one is finally served. Just when we thought the protected order matter was settled, document 95 comes along. Another Dear Judge letter. And they come back just as strong. They also mention the conference where they were able to agree on some things, but they just cannot accept that their ask is overbroad. They say that this limitation is inappropriate given the purpose of the specific discovery sought and the purpose of discovery generally. I highly disagree with that. They never said the subpoenas were for the purpose of going through every phone call and every text to find any person they ever called or texted. They said it was to get to the beginning of the smear campaign. They call the request reasonably calculated to lead to the discovery of admissible evidence. I wonder if they'd be that willing to turn over their stuff. So they say they're looking for communication not only among the defendants, but among the larger network of individuals who perpetuated the untraceable campaign against Miss Lively, and as in sovereign partners, the requested records fit easily within this broad definition of relevance, with sovereign partners being that case they just cited from. They say that the Wayfair parties have not identified legal authority standing for the proposition that subpoenas to telecommunications carriers must or even should be limited as they propose, and to the contrary, courts regularly permit such discovery. Not entire phone records like this. And they did identify legal authority. They cited the federal rule. And they conclude by saying such matters as the pattern of communications among the Wayfarer parties and unknown associates during Miss Lively's alleged harassment, as well as the inception, duration, and scope of the untraceable retaliatory campaign against her that followed. Okay, if there was an actual campaign against her, Where's the proof of that? Have they gone through any of this smear campaign and found anything that was set up by anyone specifically? Now, I could see if they traced some articles back to certain people and wanted to see if those people had been in communication with this crisis manager or this PR person that they're making accusations against. They would have a real reason to request that information. But to just ask for everyone in your phone so we can see if maybe somehow they're connected to this, it's ridiculous. And to go back to 2022, when they claimed that this campaign started after the 17-point document. That wasn't in 2022. That was very late 2023, halfway through filming. So how are they looking for a smear campaign from before there was a reason for this alleged smear campaign? Everything was great then. None of this ask makes sense. And such a violation, because what that would entail is they would have to take these numbers, every single one of them, do this reverse lookup that Team Justin specifically mentioned, just to see if that person could possibly be someone that they communicated with, in case they just might be someone who carried out this alleged smear campaign, which is preposterous. And how exactly do they intend to identify that? Say they look up 10 numbers, reverse lookup. When they look these people up, what do they expect to find them out there advertising? Hey, I do invisible smear campaigns. How will they know the difference between someone that's just a friend or someone that's calling from some agency or a wrong number? How are they going to know the difference between those people and people involved in an invisible smear campaign? And if they're involved in an invisible smear campaign, you can bet they're doing their things off the grid. They're not going to come up in some run-of-the-mill phone search. That's not how these people operate. If they're really doing stuff like this, they're probably on burners, or they probably won't speak to you over cell phone. So this whole thing is just ridiculous. Now, 96 is Ryan striking again. There's a mention of the Saturday Night Live joke, and this joke is really coming back to bite them. It was in such poor taste. And Cue Card Wally, as he's called, has supposedly come out and said that Ryan ad-libbed that joke, that it was not what he was supposed to say. But either way, whether it was prepared in advance or ad-libbed at the moment, and by Blake's face, it does seem more likely it was ad-libbed. If you're a husband who loves your wife, and I've talked about this several times, that Ryan's reactions to this are not normal. But if your wife had actually been traumatized by sexual harassment as she's claiming, and is suffering from trauma also as she's claiming, supposedly in pain as she's also claiming, why is her husband joking about it on a global stage with her right there by his side? So which one is it? Is she not traumatized to where he's free to joke about it? Or is he a terrible husband who doesn't care about her trauma and wants to continue to joke about it? Because neither scenario is very good. I had previously talked a lot about the jokes on Deadpool, and I saw some other little things in there that I hadn't noticed before. Nice Pool is killed in front of a flower shop, but what I hadn't seen was that flower shop was named Little Sage. Can you imagine? They took the time to make this set, to put a flower shop there, and to name it Little Sage. So here we are, her husband, and remember, Deadpool was filmed at the same time that It Ends With Us was filmed. They premiered for the same week. So during this time that his wife is supposedly going through this trauma, he's taking the time to add a whole character to his movie, and that we've already talked about. He added Nice Pool. He does his hair like Justin used to wear his hair, repeats the lines that supposedly traumatized her, and is being killed by the character that she's voicing in front of a shop that's like the set where it supposedly happened. And then they're further making fun of Justin's religious beliefs, because he was said to have saged the set to ward off negative feelings. It doesn't matter what you think of saging, it is a religious act. Last I heard, in 2025, we don't make fun of other people's religious beliefs. And there's no doubt that this is about Justin, because in the credits, Ryan called Nice Pool Gordon Reynolds, and Blake, and on It Ends With Us, Blake thanks Gordon Reynolds. Imagine making jokes like these, and then turning around and suing this person, claiming to be traumatized and in pain. When you're an actual victim of something like this, you don't joke like this. When you're actually in pain, when you're actually traumatized, you wouldn't think of it. It's not funny. And it minimizes and trivializes your supposed experience. And that's why we can't take them seriously, because they don't take it seriously. This is disgusting. And so Team Justin says in Document 96, given how actively the Lively parties have publicized and litigated Miss Lively's claims in the media, we're surprised to now learn how vehemently she wants to prevent the public from accessing material and relevant evidence. And they point out stuff that comes from Blake's spokesperson. One of them being an article in The Hollywood Reporter on January 16, 2025, where it says Blake Lively and Justin Baldoni's lawsuit. Another chapter in the Abuser's Handbook. They point to another one. Blake Lively's amended complaint claims Justin Baldoni made other women uncomfortable on set. Can corroborate. They say this is trying to convince the press that her amended complaint saves her meritless claim by referencing other purported victims, although she fails to name a single one. And then they mention the SNL episode and go on to say that this attorney's eyes only designation is not warranted, saying that they say it's appropriate because the litigation involves claims of sexual harassment, but that Blake has already publicized the alleged details of the so-called harassment in her amended complaint. And then state that if there is any highly sensitive personal information, that they already have these procedures in the court's model protective order put in place. And they go through what that is. And that brings us to Document 97, which is a whole new revision proposal of the protective order, where it takes out all of the references to this attorney's eyes only designation. And by the time I finished typing this, Team Blake had filed a nasty response, but I'm saving that because I want to wait for the further response to that and hopefully a conclusion to that matter. And then we get to the shocking news, and I wonder how this was able to be kept so quiet for all of this time. Racer S.J. Harris was asked to perform a motorcycle stunt in Deadpool 2, something that she was not qualified to do. It states that the producers were exerting pressure to have her perform the stunt because, as an African American, she was a believable stand-in for Zazie Beetz. Multiple crew knew that she wasn't ready, warned against her doing it, and described her as not really wanting to do it. But after repeated pressure from producers, she did. She was killed on the first live take because they'd also asked her to do it without a safety helmet. The movie was filmed in Canada, so it was investigated by WorkSafe BC, which is the Canadian equivalent to OSHA. They found numerous violations, and 20th Century Fox was fined almost $300,000. They later settled with her family for an undisclosed amount. And here we see a list of producers. The two PGA producers were Simon Kinberg and Ryan Reynolds, with only one other person listed as a producer and the others as executive producers. And this is what happens when you're impatient and you push for what you want without taking anyone else into consideration. I'll have more on the Justin Baldoni-Blake Lively lawsuit soon. Till then, this is Cassidy O'Connell saying stay well and stay tuned.